Rapper Young Thug, a free man for the first time in more than 2.5 years, discreetly chauffeured in this Mercedes with his attorney through a back gate of the Fulton County Jail just hours after accepting a plea deal.
How do you plead?
Guilty.
The 33-year-old, whose real name is Jeffery Williams, pleaded guilty to gang, drug, and gun charges. The judge then sentenced the Grammy winner to 40 years in prison with 5 years to be served, then commuted that to time served. Now he's on probation for 15 years, under the condition he stays away from Atlanta except for major family events like weddings and funerals, and mandatory community service in the form of anti-gang and gun violence presentations.
I take full responsibility for, my crimes or my charges.
This was a huge risk with a huge payoff.
Young Thug took what's called a non-negotiated plea deal, giving Judge Paige Reese Whitaker, who only recently took over the trial because the original judge was removed, complete authority over his sentence.
What changed was that there was now a person sitting with that robe, a judge that is going to be fair.
The YSL trial is far from over. 2 of Young Thug's co-defendants, Diamante Kendrick and Shannon Stillwell, are still being tried back in court on Monday.
About this trial of the century, Georgia's longest trial and one that has captured national attention. Of course, we have to bring back our favorite Atlanta attorney, Josh Schiffer. Josh, you are not personally tied to this case. You have not been a representing attorney in this case, but you have been following trial, as many of us have. And you were watching yesterday as we heard the defense team, Young Thug's attorney, say that they are going to enter a non-negotiated plea deal. And a lot of folks are really trying to wrap their heads around everything that happened as we took them through this, as we took them through the plea deal process, and then what ultimately was a shocking sentencing. But I want to start from the very beginning. What was your reaction when you heard that a plea deal was about to go down?
I was absolutely shocked. I had just finished speaking with a few of my colleagues and members of the press about how exciting it was going to be to get back to a newly reformatted trial with substantially less co-defendants, really thinking about how Judge Whitaker was going to handle the smaller trial, what part of the state's cases were going to be removed due to the previous pleas that we've seen over the end of last week, beginning of this week. The case changed so dramatically, but we expected to see 3 co-defendants, including Jeffery Williams, continue to stand up for their rights against the state's presentation of their evidence. We were all very surprised then at about 4 o'clock yesterday afternoon with the announcement that a plea agreement had been reached, and we immediately knew that both sides had to have given up substantial ground in their negotiations. We understood that there were some generous terms being discussed for a plea for Mr. Williams, also known as Young Thug, but that some of the other onerous requirements the state was requesting were never going to work for Mr. Williams and his ability to continue his career, his musical production, and be a successful citizen. And they didn't agree. Let's just be very clear about that. What we saw yesterday as part of the sausage making we call criminal justice was an agreement that a plea should be entered. And any defendant can take a plea at any time during the trial. It's just not negotiated. You can stand up, use your First Amendment rights, and say, Judge, I plead guilty to the charges presented in the charging document, in this case, an indictment. But as for sentencing, there's no agreement there. And we didn't see an agreement between Chief ADA Love, the state's prosecutor working on behalf of DA Fonnie Willis, when she set forth at the beginning of the plea what the state wanted and the facts justifying the state's recommendation of 45 years, do 25 years in prison. Only then did we find out that there were offers on the table that basically were a bunch of probation, some backloaded time. But Mr. Williams, had he agreed to the plea offer, would have walked out of jail a long time ago. However, there was such a substantive disagreement as to the special conditions of that sentence that no agreement could be reached. That's why we were having the trial with Mr. Williams. By taking the risk of presenting that plea naked to the judge, asking, basically, Mr. Steele and Mr. Keith Adams, Young Thug's lawyers, said, Judge, we want to plead guilty to these specific charges. We understand the range of sentences. We take responsibility and say that there are enough facts to justify a conviction, not that the defense at all agreed with the factual recitation of the state. In fact, we had some really good conversation and watching some fantastic lawyering, how Brian Steele specifically evaded many of the allegations made by the state when it comes to Jeffery Williams, and Jeffery Williams admitted guilt only to the crimes that supported his conviction, not the specifics. That allowed Judge Paige Reese Whitaker to issue a sentence that she felt was fair and met the substantial best interest of justice, and that sentence is a probated sentence. There are risks on the back end if he violates that probation, but should Jeffery Williams comply with the terms of his sentence in probation, he is a free man who will be a successful entertainer moving forward.
This all started because of a mistrial motion, but there have been countless of mistrial motions throughout the course of this trial and witness testimony and presentation to the jury. What was it about this one that really got the ball going?
It really was the first time that the judge had come out and weighed in on, let's just say, the strength of a mistrial motion. We've seen dozens, literally dozens. I can't think of a trial that's had more mistrial motions over the last 150 odd days of trial, some of which were very quick and just immediately denied. Judge, that's wrong, mistrial. Other mistrial motions were very thorough. Brian Steele previously filing a detailed, extensive written motion for a mistrial that we all understood to be a precedent or a setup for a court of appeals, because they understood, likely, the court was going to be denying a mistrial. A mistrial is an extreme remedy available to the court only where really the trial has been deemed unfair. We've also discussed with this mistrial the idea of with prejudice or without. And when this mistrial motion, the most immediate one, was mentioned last Wednesday, immediately Judge Paige Reese Whitaker said there's not going to be a mistrial with prejudice. The person who had issued or had stated the inappropriate character evidence didn't do it intentionally. It was not something that was planned or contrived. It was a legitimate mistake. So a mistrial with prejudice didn't seem to be on the table. However, she was very open and basically asked the parties to talk about a mistrial without prejudice. That's a telegram to the state and the defense that things have changed, that the fairness, the independence, the rules and requirements of the actual superior court may be threatened, and the judge may need to act. By saying, I may act as the court, it spurs the defense and the state to get together and mitigate the positions that they've got, ensure that the strengths and victories they've won are retained, while also admitting and acknowledging the parts of the case that they've lost. And by coming, during these decisions and negotiations, by coming to agreements, we've now seen all but 2 of the YSL co-defendants in this trial now enter guilty pleas, leaving the 2 with very serious charges left to face justice in front of this existing continuing jury.
And I want to talk about those 2 remaining co-defendants, because this trial is not over. As much as Young Thug did go home last night and heard his sentencing and all that came to a head, there's still a trial to be had with 2 co-defendants, and we'll talk about that. I just want to talk for a moment and get your perspective on the different types of pleas that we heard. We heard a NOLO plea, no contest, and then we heard guilty pleas on some of the other charges. Williams overall facing 8 federal charges. Why was
felony,
that? Felony charges. Why was the decision? What was the thought process for the defense, I should say?
It's really this is the most complex and nuanced kind of negotiation you have, and we saw Jeffery Williams enter guilty pleas on, I believe, 6 of the 8 charges that he eventually received a disposition or adjudication on. The big difference are the 2 charges, specifically RICO, that he pled no contest or nolo contendere. Nolo contendere or no contest is not an admission that you did anything. It is indicating to the court that you are not going to contest the state's allegations and you are going to accept the conviction. It matters more in the civil realm than the criminal realm because the admissibility and voluntariness of the criminal disposition is treated differently in civil court when there is a nolo contendere. You'll oftentimes see that in something like a car accident, or if there was a civil penalty attached to a criminal conviction, such as when we used to suspend driver's licenses for marijuana possession. You would see a lot of nolo contenderes there. It's, I'm not contesting it. That's different from the straight up, I'm guilty, I take criminal responsibility that he entered on the remaining 6 charges. What we didn't see yesterday is as telling. Mr. Williams did not use his first offender rights. There could have been a discussion involving first offender, the risks and rewards of proceeding under first offender, and as I understand, many of the charges would have been open to first offender. If you successfully complete first offender, you've never been convicted. The state, it's a plea and abatement. The plea is basically stored in a file cabinet, and if you complete the plea, you get to rip it up, and it basically never happened, versus if you violate the terms of probation, rather than a standard probation revocation, you actually face a resentencing under the Georgia First Offender Act, and the court can resentence you up to the maximum time allowed by law for your case, even if you did not plead to that length of case initially. We also did not see conditional discharge, which is basically first offender, except it's only for drug cases. And Mr. Williams did plead guilty to multiple VGCSA, or violation of the Georgia Controlled Substances Statute. I believe it was mostly cocaine. These combined charges are awful. They would stop the progress of the vast majority of individuals who work in the regular economy. These are really serious, but it's different for Mr. Williams due to his profession. Mr. Williams' biggest concerns were being able to continue practicing his chosen career of music, being able to travel, being able to work, being able to get into countries that might not want someone with his record. Preserving that ability and his earning capacity in the immediate future was very valuable to the defense, and they emphasized that in their request to Judge Paige Reese Whitaker to allow him to leave jail immediately, and it worked. That's really one of the big takeaways that we are all talking about. The state told Mr. Williams, you are such a criminal that if you do not do what we want, you should stay in prison for 25 years. However, if you give up your money and your career, we will give you probation as your sentence. And that's not landing very smoothly with the general public from my experience. A lot of people are asking me, Josh, why would they hold someone in jail and put them up for facing hundreds of years if all this time they were willing to give them a time-served plea? That conversation is extraordinarily important, and I hope that it resonates in our community, because those are the answers we deserve from our elected prosecutors, such as Fani Willis, who is walking away from this case with some big victories. She got her convictions. The cost for that, the reflection on that, and how this affects her as well as her staff moving forward, that's the story we're really interested in. Can someone like Chief ADA Adrian Love, previously a candidate for office, can they effectively run for public service again? What will the roles be, and what is going to be the result, the ramifications of Georgia's longest criminal trial?
Well said. We're talking with Josh Schiffer, of course, Atlanta criminal defense attorney. Let's talk about the 2 co-defendants that remain right now. You know, we have emphasized this yesterday, and we want to continue to emphasize this today. This trial doesn't end with Young Thug's sentencing. We still have 2 more cases to hear out, and we know that in one of those, there was an outright rejection of a plea deal offer with DeMonte Kendrick, also known as Yak Gotti, his attorney, saying that he, quote, fully intends to take this to the jury and get our not guilty verdicts and go home, end quote. And then there's still much to be learned about the other co-defendant in this, Shannon Stillwell, or SB, as he is known as, who faces 8 counts. He has not stated whether he will consider a plea deal and whether what Young Thug did changes all of that for him. Absolutely,
and that's some of the interesting calculus going on behind the scenes. We know Yak Gotti, his lawyer, Doug Weinstein, has taken a very public position in this trial, working together with Jay Apt and Katie Hingerty at a wonderful firm doing tremendous work. And then, of course, Maxwell, standing up for Mr. Stillwell. It's become a meme how aggressive Mr. Shart has been in standing up and defending his client. Both of those gentlemen are facing extensive prison sentences. They have very different cases and allegations than those against Jeffery Williams, including sufficient crimes of violence. Violent crimes are where the state has the most effect when it comes to appealing to a judge's interest in justice. Judges get a little bit wishy-washy when it comes to victimless crimes such as drug sales or theft crimes where there's not any violence. Violence is at the heart of every judge's wants, needs, and wishes serving the public, and stopping the violence, protecting the community. So, with the violent allegations facing the two remaining co-defendants, that's a different plea negotiation entirely. When you have excessively violent acts, including murders, things like that, the court can't sit back and talk more about probated sentences and giving someone an opportunity to succeed because of the damage done through the violence. And that's a big difference in all of the demeanor, the tone of the negotiations, and what's on the table. We do get to continue this trial. It will be aggressively defended as well as prosecuted, and it's the same jury that heard all of the evidence over this last 150-something days. That brings up an interesting issue. All those appellate issues that are now going to be avoided by Jeffery Williams, by the other co-defendants, those are still live for the two remaining co-defendants. Should this case reach a verdict, the Court of Appeals will almost certainly hear from the parties involved and have an opportunity to review vast chunks of this trial.
So far from over. Court resumes at 8:30 a.m. Monday, and you know we have been here gavel to gavel, and we will continue to do that for you on Atlanta News First and Atlanta News First Plus. Josh, we could stay up here for several hours talking about this.
Love it.
Because it's just fascinating to watch.
This is so important. It doesn't strike home until you look into the faces of your children and your friends and you understand that these are the people involved. These are real human beings. And you can tell the engenderment of connection. You almost see some of the humanity in the glances between the co-defendants and the deputies who have spent months protecting everyone, not just the judge. Those deputies are there to protect and serve everyone. This is such a unique chapter in Georgia's history.
Certainly, and I want to make sure that as we continue to cover this trial that folks can connect with you, whether it be to hear more of your analysis or to hire you as a defense attorney. How can people reach you?
You can always just Google me. I'm Joshua Schiffer, spelled the same as the beautiful model from the 90s. I am not her nor related to her. I believe my partner has a website for us. It's jdlawgroup.law, jdgrouplaw.law, something like that. But just look for me. I'm tough to miss, and I love talking with people.
And we're going to continue to cover analysis of Young Thug's trial and the case involving the two remaining co-defendants on Atlanta News First. Our news starts at 3. We hope you'll tune in.